Good morning, everyone. This is the time and place for zoning cases hearing for Wednesday, December 15th, 2010. My name is Kristen Asp, and I will be conducting the hearing as hearing officer. We have one item today on the agenda, and the relevant exhibits are posted on the board directly behind me. It is an application for a variance, and I'll just outline some of the procedures for today. Under the provisions of Title 30, Chapter 30.43 of the Glendale Municipal Code, a variance shall be granted if four required findings are present. Number one, that the strict application of the ordinance would result in practical difficulties or unnecessary hardship inconsistent with the general purpose and intent of the ordinance. Number two, that there are exceptional circumstances or conditions applicable to the property involved or to the intended use or development of the property that do not apply generally to other property in the same zone or neighborhood. Number three, that the granting of the variance will not be materially detrimental to the public welfare or injurious to the property or improvements in such zone or neighborhood in which the property is located. And number four, that the granting of the variance will not be contrary to the objectives of the ordinance. For the findings, if the evidence presented in the application and at the hearing meets the criteria that I just described, then the planning hearing officer can either improve or impose conditions for approval on the case in question. If the findings of fact are not evident, then the request will be denied. Public notice. Notification of this hearing was accomplished by the use of public notices which were mailed to property owners located within 500 feet of the subject property, physically posted on the site in question, and placed in the local newspaper and posted on the city's website. Just procedurally about the hearing, I'll read the description about the request. I'll read any relevant reports from other city departments or letters of communication from interested parties. I will then ask the case planner to briefly give an overview of the case, give some analysis and make a recommendation. I'll then ask the applicant to come forward, and they have 15 minutes to present their case. Any others in support of or in opposition of the case can then come forward. They're limited to 3 minutes. And then lastly, the applicant will be given the opportunity to make any closing comments with a 5-minute time limit. And then we'll close the hearing and take the case under submission. About the decision. After the hearing, the decision will be prepared in writing and will be in the form of a letter sent to the applicant and to all persons who responded to the public notice, either by speaking at this hearing or by submitting written responses and have provided their name and mailing addresses. The date of the decision will be the date appearing on the letter. Under the appeals provision of Title 30, Chapter 30.62 of the Glendale Municipal Code, the decision may be appealed to the Planning Commission within 15 days of the decision date. That would be the date on the letter, and the notice of appeal shall be filed with the Building and Safety Division located in this building, MSB 101, the first floor of this building. If you wish to speak, please write your name and address on one of the speaker forms. I have a few up here already. And I'd like to inform everyone that the official proceedings of the planning hearing officer's hearing are recorded on tape as part of the public record. So now that procedural stuff is out of the way, let's get started. The item on the agenda for today is a variance case, number PVAR 2010-018, located at 1372 Opeechee Way. The applicant is Vic Mardian. Owner is Vahe Hartamian. And the case planner is Mr. Rather Duong. I will just read the description. It's an application for a standards variance to legalize an unpermitted retaining wall which exceeds the maximum height and providing less than the required interior setback for a new residence caused by the combined removal of more than 50% of the exterior walls and roof area, in conjunction with the proposed remodel and legalization of a floor area addition located at 1372 Opeechee Way in the R1R restricted residential zone. I'm going to ask the case planner, Mr. Duong, to give a brief overview of the case, and we'll go from there.
Thank you, hearing officer Asp. Good morning, everyone. The case before you, as you stated, is case number PVAR 2010-018, located at 1372 Opeachy Way. First, I'd like to go over just a little bit over the existing property, and then followed by a little bit of history behind this request, as well as the current proposal. The subject site is a hillside property located north of San Luis Rey Drive and south of Salvas Place. This property is located in the R1R zone and in the Woodlands neighborhood. The lot is irregularly shaped and contains approximately 11,970 square feet. The lot also slopes from the street towards the rear of the property. This site was originally developed in 1920 with a single-family residence and a detached single-car garage. The original garage has been demolished, and the existing architecture of the house has been modified as we see today. The existing condition also includes a substantial amount of construction, such as floor area addition to the upper levels, construction of a new detached garage with a second floor livable area, which we consider as a guest house, retaining walls at the rear of the properties, as well as architectural modifications to the appearance of the residence. On the site also exists several oak trees located at the rear and along the side property lines. The residence is located far from the front property line, approximately 46 feet 4 inches away. This distance is significant in comparison to the adjoining properties and other homes in this neighborhood. The majority of the properties in the neighborhood are located closer to the front property line. For example, the property immediately to the south is situated about 20 feet away from the front property line, while the property to the north is approximately 24 feet away. In terms of the history, this project or this subject site has a long history. It started in January 29, 2007, which neighborhood services identified the violation that currently exists on the property. The current owner at that time went through the legal process with the city attorney's office, and eventually an application for standards and setback variance was submitted to the planning division in December of 2008. The applications were deemed complete in March of 2009, and the case was heard by the hearing officer on September 16, 2009. Subsequently, that case was denied by the hearing officer on September 23, 2009, and the applicant and property owner at that time filed for an appeal before the Planning Commission. On December 16, 2009, the Planning Commission denied that appeal. Soon after, the property went into foreclosure and the property changed hands, which was purchased by the current property owner before you today. That property was purchased on May 25, 2010, and on October 7, 2010, a new revised application was submitted to the Planning Division by the new applicant and property owner. This applicant reflects a substantial departure from the previous application submitted by the previous owner. The biggest change is in the number of variances that are being sought. Originally, there were 8 items pertaining again to the illegal retaining walls, which exceeded the number allowed by code, the slope between the walls, and the height. And then the other major variance issue was the construction of a detached garage without permit, as well as the guest house above it. These items did not meet the setback, as well as the height related to accessory building. And it also covers the retaining wall to the north. So all in all, the new application is significantly different because the applicant and the new property owner is proposing to correct as many violations as possible. Therefore, he's proposing to demolish all the retaining walls in the back as well as the steps and stairs, the existing unpermitted one-car garage and the guest house. By demolishing these structures and buildings, essentially all of the violations that were identified previously will be removed as well. So in the end, only 2 items are left that are being sought and before you today for your consideration. These 2 items involve the retaining walls and the setback both located along the north property line. First of all, the setback request, well, let me just, these requests actually is closely related to the overall project, which also include the facade remodel of the house, as well as new addition to the property on the first and second floor, construction of a new 3-car attached garage, as well as legalization of the unpermitted addition that took place before the current owner acquired the property. So all in all, in combination, those changes would require the property to have the exterior walls and the roof area combined exceeds the 50% maximum threshold. Therefore, it causes the property to lose its non-conforming rights in terms of the setback and everything else that pertains to the property, including the retaining wall. Essentially, we would have to consider as new construction, even though it is not a complete tear down of the property. So, if I may approach the board, this is probably easier to see because as you can see, the subject site is irregularly shaped. Also, it is wider at the front than it is at the back. It tapers toward the rear. So the area in question pertaining to the requested height exception to retaining wall and the setback is located towards the rear of the property, where the property tapers toward the rear. And also, an important point to consider is the relationship between the subject property and its adjoining property. As you can see, the subject property is located to the rear of the lot, further away from the adjoining property, as well as other properties in the area. This is a topo map that shows the outlines of the buildings in the neighborhood. And you can clearly see that this subject property is situated further away than most or all of the properties in this area. The requested setback does not cover the entire length of the building. It only covers a small portion of the area because of the narrow effect of the lot as you approach the rear. Most of the building and the retaining wall meet the minimum standard in terms of setback and height requirement. It's only in this area where it becomes a contradiction with the zoning code. So, and also this property to the north is on a higher topography than the subject property, and the neighboring property to the south is lower topographically than the subject property. So if you were to stand on the street looking towards these properties, you would see a stepping effect. So this condition necessitates this retaining wall, because without this retaining wall, you would have a slope that would fail and would not be possible. And in terms of observation and my experience, it appears that the retaining wall may have been there or was necessary in order to develop this lot due to the grade change. Originally, yes. So it's the fact that it also appears that it may have been constructed of railroad ties back in the days, because you can still see remnants of railroad ties on the property as well as on some of the lower retaining walls. So the fact that the property is proposing to remove more than 50% of the walls and roof in conjunction with the change of material from railroad ties to concrete block wall, which constitute new retaining wall. So,
can I ask a question about the setbacks?
Yes.
So for the structure, for the house, there's a request for
a 10-foot setback, a 5-foot setback.
A 5-foot setback.
Right.
And is that an existing condition? And like, was the house always the original house always set back at 5 feet? And so because of the 50% loss of non-conforming setbacks for that, there's no change proposed in that corner of the original house?
Yes. The 5-foot setback that's there right now is to the existing first floor of the house,
okay,
which, based on, again, observation and condition of the property, that appear to be the original condition.
Okay.
So the requested setback is 5 feet in addition to what's there right now. And also in terms of square footage, we're only talking about 50 square feet on the first floor and 50 square feet on the second floor that are located within the required 10-foot setback. So in conjunction with the overall size of the house, concluding the new proposed addition as well as the legalization of the unpermitted addition, that's a small fraction, because the proposed size of the house eventually is about 3,000 plus square feet, 3,500, I believe.
Just over 3,500? 3,526?
Yeah. Thank you. So again, the total length of the retaining wall running along the north property line is about 83 feet long. Its height fluctuates between 2.3 feet to 9 feet 8 inches, depending on the natural topography. The length, which exceeds the 3-foot maximum height and is located within the 5-foot interior setback, is approximately 60 feet long. The 9 feet 8 inch high portion accounts for approximately 12 feet of the entire wall, or 20%. So the wall becomes shorter as it approaches the front of the property. Obviously, that is again caused by the changing topography.
Okay.
Concerning the addition, the applicant is proposing 657 square foot addition to legalize an existing unpermitted addition totaling 657 square feet, as well as a proposal to add 920 square feet on the first floor and 207 square feet on the second floor. And as I stated earlier, the project also includes a new 3-car garage. The addition, as well as the facade change, will necessitate the review and approval by the design review board, which will, depending on the outcome of this case, will be considered will be considered by the design review board as the next step.
Okay.
Now, as I briefly stated earlier, the combined length of the building along the north property line is 59 feet long. That includes the building, the livable area, as well as the porch that projects towards the rear. The portion that does not meet the 10-foot requirement is 28 feet long. 7 feet of that is the balcony, and 20 feet of it is the building. So in total, this accounts for about 47% of the total length of the wall on the north side of the building. In terms of the square footage, 35 square feet of the balcony and 100 square feet of the floor area, this is on both levels, are located within the 10-foot required setback area. The size of the proposed residence, including addition and legalization, is 3,526 square feet. And again, from this perspective, this accounts for a small portion of the building, approximately 2.8 or 3% of the total floor area. Based on the site planning of the subject parcel, the existing residence, proposed legalization, and new addition, staff believe that the two variances warrant positive recommendations given the unique site planning and the lot shape and the sloping topography, and that its relationship to the adjoining properties. Again, the requested setback variance and the retaining wall would mostly impact the property to the north, but because of the site planning of that property and the subject parcel, the encroachment of living area and the balcony into the setback would not impact the property to the north as one would believe, because that area is entirely open space or the rear yard of the property. As you can see again, the subject property essentially doesn't start until at the rear of the property to the north.
And I think you can tell that in this
Correct.
building
So
print of the neighborhood.
if there is any impact, which staff doesn't believe there is, or if there is any, it will be very minimal due to the fact that it does not overlook any livable space of the adjoining property. And in terms of the property to the south, the setback on that side will be complied with the current zoning code, which is 10 feet. And also, the applicant is proposing to remove some of the pavers along the south property line and will provide new landscape, and which would eventually provide additional buffer to that property. And additionally, along both sides of the property, you have 2 mature oak trees that also will act as buffer in terms of, which also helps in terms of the requested variances. The proposed addition will also be located in the flattest area of the lot, so therefore it will not change or compromise the natural topography of the lot, because essentially it will be on the second level and in an area that's has already been graded previously. Staff have also worked with the applicant in terms of refining the design so that it's more in keeping with the neighborhood in terms of its mass, its scales, and its architectural style. Overall, the proposed project is more in keeping with the existing character of the neighborhood and will be a big improvement from the existing condition. Based on those on that analysis, staff recommends approval of the project with conditions.
Thank you. I will note that I did forget to go through the comments from other departments, and I will just very briefly run through those, because in looking at this, I don't see anything significant from other departments. There are some standard conditions from fire that will be involved should this get approval and pull a building permit. Neighborhood services, just I think outlined all the previous violations that currently exist on the property and how to perhaps go about correcting them, which include applying for a variance. Most of these are relating to permit issues from water and power. No comments from traffic. Public Works. Nope, I don't think there are any significant comments. I just wanted to make note of that for the record, and we will open the public hearing, and I will call the applicant to come forward. Vic Mardian.
Good morning.
Good morning.
Hearing Officer Aspa. My name is Vic Mardian, 416 North Glendale Avenue. I represent Mr. and Mrs. Hatamian. They're the new owners of the property located at 1372 Opeachy. At this time, Hearing Officer Aspa, if I may request some additional time if necessary, because of, as you know, the case is has a little complexity and issues.
Has some history.
Some history, yes, absolutely. I'll start with the findings and go
Okay,
over
you think you're going to need a little bit more than 15 minutes, or?
I hope not, but if I may, can you allow
Okay.
me the latitude, please?
Sure. If you're going to, I would ask you to go over the findings and maybe walk us through a little bit of how you came to this design.
Of course. I'll start with the first finding. How will the strict application of the provision of any such ordinance result in practical difficulties or unnecessary hardship related to the property, inconsistent with the general purpose and intent of the ordinance? As staff stated, the subject property is in irregular shape hillside containing 11,970 square feet and slopes upwards from the street toward the rear of the property. Subject lot currently zoned R1R2 and is developed with a single-family dwelling residence built in 1920, including a detached one-car garage, which has been demolished by the previous owner. Over the years, the subject property has incurred several legal conditions, staff stated. In addition, alteration including facade alteration without permits created by previous owners which do not conform to current standards. The proposed project and the improvement will rectify majority of the illegal conditions and additions created by the previous owners, with the exception of the following items which were variances requested. First is to legalize the existing retaining wall located at the property line within a portion of the 5 feet of the interior setback at the east side with a visible height of 9 foot 8 inches. Second, legalize and maintain the existing building 5 feet interior setback in lieu of 10 feet due to the improvements that exceed the 50% threshold of non-conforming building. The strict application of the provision of the ordinance would result in practical difficulty or unnecessary hardship, inconsistent with the general purpose and the intent of the ordinance. As far as for the first variance request, the original footprint of the structure has not been changed, and in order for a variance not to occur, the total structure has to be demolished. To legalize the existing retaining wall location at the requested height is necessary to retain the slope of the adjacent property. To remove it will create a safety hazard and condition. The railroad ties that were previously located at both properties support the earth is not an acceptable permanent solution and will not meet today's code requirements. In addition, to recreate the original condition would require work on the adjacent property, which is not feasible for or permitted. Furthermore, only a portion of the wall, as staff stated, that exceeds the height within the 5 feet of the property line, ranging from 4 feet to maximum 9 foot 8 inches. The second variance request is to deviate from the code of the building setback to the improvements exceed 50% alteration to the structure is also a hardship and a practical difficulty. The 5 feet existing house setback building, the floor level has been established since 1920. Because of topography and it cannot be reversed, the existing house front setback is approximately 47 feet. The 5 foot interior setback deviation from the code is only a portion of the first and the second floor to the southeast corner. as again staff stated. In addition, the location of the variance request for the interior setback is not visible from the street, nor will infringe on the adjacent property, and is a minimal request and clearly consistent with the intent of the ordinance. Furthermore, the maximum structure height is 10 inches high, and the zoning code allows up to 35 feet in an R1R zone with a 6-foot setback. The proposed design, including improving mass and scale aesthetic, is sensitive to the topography and compatible with the neighborhood that will further reduce the height, appearance, and be consistent with the city design goals, including the single-family design guidelines. In conclusion, for the first part of the finding, the proposed project will rectify majority of the self-imposed illegal conditions created many years ago by the previous owners, with the exception of the requested deviation, which cannot be rectified or reversed unless the entire structure is demolished. Therefore, to enforce a strict application of the code would be practical difficulty and result in an unnecessary hardship. Pertaining B, what are exceptional circumstances or conditions apply to the property involved or intended use of the development of the property that do not apply generally to other properties in the same zone or neighborhood? In this case, there are exceptional circumstances or conditions applicable to the property involved or to the intended use of development of the property that do not apply generally to other property in the same zone or neighborhood. The existing lot is irregularly shaped and topography and was developed in 1920. The existing house is located closer to the back hill, which is unlike the adjacent properties in the site characteristics and planning, and developed closer to the street in the flat portion with less front setback. The retaining wall is necessary to support the slope of the adjacent property. The building setback of 5 feet was created when the property was developed. Due to the nature of the topography and the new house design with the requested division will not be intrusive on the adjacent property and will be mitigated by the proposed design mass and scale. In addition, the proposed project and the improvement will also preserve all protected indigenous trees existing on the property, including providing additional mature trees and landscaping to further reduce the scale and the perception of the building mass. Pertaining to C, why will the granting the variance not be detrimental to the public welfare? The granting of the variance will not be detrimental to the public welfare or injurious to the property or improvement in such zone or neighborhood in which the property is located. The use of the property is single-family residence and will continue as such. The proposed improvement will rectify all the legal conditions and the floor area additions created on the property over the years by the owners and bring it to conforming with the current standards, which will become consistent with the other developments in the immediate area. Other than the exceptions requested, the project will incorporate all current zoning, floor area, ratio, lot coverage, number of story, height, and landscaping, including single-family design guidelines, which will result in higher quality design compatible with the surrounding properties. To maintain the existing location of the house and retaining wall height within the portion of the southeast corner of the building will not be detrimental to the public welfare or the safety. In fact, without the retaining wall to support the slope of the adjacent property will be a safety hazard and detriment to the neighbor. And pertaining to D, why will granting the variance to be in keeping with the objective of the ordinance? The proposed improvement scope of work is to demolish the existing two-story accessory structure with a non-conforming garage and provide code-compliant garage and proper setbacks. Removing the excessive number of retaining walls, replace them with one 9-foot-high code-compliant retaining wall with a 2-foot freeboard to recreate the existing back slope and bring the original terrain. In addition, the new house design will maintain a 2-story conditions throughout the structure, eliminate the 3rd and the 4th story conditions that have been created by the previous owners. Therefore, granting the variance will not be contrary to the objective of the ordinance. The standards of the residential development is in furtherance of both providing necessary living quarters and quality of single living environment, single-family living environment. The building interior setback will be mitigated by the proposed improvement and promote good site planning. and the building aesthetically pleasing in the mass and scale with the neighborhood development. Statements of additional facts related to the variance request. The proposed project, again, will rectify a majority of self-imposed illegal conditions and additions created many years ago by previous owners. The code permits up to 3 consecutive retaining walls, maximum retaining wall of 15 feet. The proposed site improvement will provide a new retaining wall as part of the garage and attached to the existing house that is not visible, including the removal of the 8 consecutive number of retaining walls and replacing them with a 9-foot-high code-complying retaining wall to recreate the back slope and to bring back the original terrain. The site planning and design approach is the most logical and is sensitive to and that respects the natural topography. The design with the attached garage to the house will also provide a 10-feet interior setback, which will be a buffer with the neighbor. The grading condition that has been created will not make it feasible to provide detached garage and will require an additional retaining wall that is visible and in turn exceeding maximum number of permitted height limit of the retaining wall due to the 9 feet grade change between the garage and the house of the floor, and the house floor level. In addition, the new house design will maintain a 2-story condition throughout the structure and will eliminate the 3rd and 4th story conditions that have been created. The proposed additions, including the improvement, will also preserve and protect, as I mentioned before, all oak trees on the site. The requested deviations are necessary to rectify the conditions that have been created and cannot be reversed unless the entire structure is demolished. Furthermore, the project will also be reviewed by City's Design Review Board to ensure compatibility and consistency with the adjacent properties. Granting of the requested exceptions is a reasonable request considering the topography of the site, including good design, will not have any effect on the surrounding properties and will be in positive impact to the community. To enforce the strict application of the code would be a practical difficulty and therefore result in unnecessary hardship. At this time, I also like to submit a signed document. I don't know if you want the original or a copy of 18 immediate neighbors in support of the...
We could take a copy, I think.
Roger. Also, I'll give a little history. We've been working on this project, as staff mentioned, maybe about 5 months ago. I also contacted the Verdugo Woodland Homeowner Association initially prior to submittal of the application, just to introduce ourselves as the new owners and show them what our proposed design was. And we met with the Homeowner Association. They were gracious enough to accommodate us. And I briefly kept them informed. And again, I have the neighbors' support, and if you have any questions at this time, I'll be happy to answer it.
Okay. I guess just from what staff outlined and what you discussed, the previous variance application was trying to correct and legalize a number of violations.
Correct.
And so that was denied. The property went into foreclosure. A new owner came in and contacted you, and there's been a redesign
Absolutely.
of that to eliminate as many variances as possible.
Yeah, we've eliminated actually 7 of 9.
Okay.
And the first submittal, that's why we revised the plans, was we still had a 3-story condition occurring. So we revised the plans with staff help and Stephanie Reich from Design Review,
Okay.
and also from Howard Mellis to come up with a design that will maintain a 2-story and eliminate the 3-story variance. Because right now, the way it's been created there, it's almost 4-story with a loft.
Okay.
So we've come back and reconfigure, and that's the reason actually why we exceeded the 50% issue as far as losing the nonconformity to create all this design and reduce the variances, make it more code compliant, we had to alter, the roof and
Okay.
make it more in keeping with some sort of a style, because I don't know if you've been to the property, but the house
I've
condition
driven by.
right now is in a disarray, and we like to correct it, and the owners are also a resident of Glendale for over 30 years, and they want to create a home there. Been searching for a home for a number of years, and they love the neighborhood, and they want to rectify all the conditions as much as they can without tearing the house down.
Okay, so I guess that's sort of the crux of my question is, this redesign is as redesigned as possible without completely tearing down the house to eliminate the need for this variance request.
Correct, yeah.
So this is as close as you were going to
close as
come
we can get
with
it,
this
yeah.
redesign. So it's a
Especially with the retaining wall, there's nothing we can do. I mean, in order for that retaining wall to be code compliant, I literally have to bring this building back at least 15 feet to make it work.
from the property line
From the
and
property.
redesign a new retaining wall.
Well, then the house is gone. I mean,
Right,
but,
right, with actually
yeah, I mean,
completely scrapping the site and
Yeah, we'll have to tear it down. I
Starting
mean,
over.
and we were trying to preserve it. Now, yeah, knowingly the owners knew that they bought this with all these issues and the non-conformity, and as we proceeded with the application, several other issues came in play.
Okay.
So, yeah, we couldn't predict 100% that we're going to try to make it work to the code. I mean,
And
Sure.
to your knowledge, and I guess to staff's knowledge as well, that the original house always had a 5-foot setback.
Correct.
And there was probably some version of a retaining wall
There were railroad
in that location at some point at an
have
unknown
disappeared.
height.
Yeah, I mean, there's a topography. There's photographs there that show the topography in relation to the wall. I mean, there has been a great difference of 9 or 8 feet, even, a little more as you go up. I mean, there's a topography there between the neighbor. And we have to put a wall. A 5-foot wall is not going to be able to do it without doing work on the adjacent property.
Okay.
We don't want to.
And I know that there were no, kind of on a separate topic, comments from the urban forester, but I know that there are protected trees
There are
and oak
protected
trees
trees?
on the site and adjoining. Have you?
I've contacted, actually, when the owners bought the property, I made the point to contact Annie Sheets.
Okay.
And she met with me at the property line.
So you're aware of
I'm
any
aware of it.
conditions that they
Actually,
want to
we've
place?
submitted a letter to her. It's just our arborist didn't sign the letter, so she wanted the letter signed, and our arborist is out of town for a few days. But the mitigations that he proposed are sufficient to her. But it's not in your packet.
Okay. So if there was a condition related to the oak trees that they satisfy?
We're not
you would be
intending
okay
to
with
remove
that?
it unless if they tell us to remove it. Unless the urban forester says remove it, we'll have to replace it with another tree. We'll have to replace it with another tree.
Okay.
I think her concern was the tree up on the hill where the grading has occurred because some of the roots have been exposed.
Okay.
And she was more concerned about that.
Okay. These are the oak
Which
trees
is way
that are-
up on the hill there.
These are the oak trees that are on site?
Yes.
In this
yeah,
location
yeah.
here?
And there's one on the south there where the garage is, correct. And there's one up on north there.
Okay, and this is because of the relation
Yeah.
to the structure that was
Correct.
built there that's being proposed to be
Yeah,
demolished?
further even away, actually, the structure that is present right now is a few feet away from the oak tree. Now we're going further.
I think I see this.
Right, that dash line there.
Here, so there's a significant setback from.
Correct. And that's for preservation of the oak tree. We're trying to preserve it.
Okay. And the overall height of the whole project?
Well, as
ends
it
up
exists
being-
right now, which is 10 inches.
That's the existing
That's
height
the
now?
existing height right now, from
Okay.
the lowest point, which is the garage.
Okay. So even if you weren't exceeding the 50%
So
rule, the
we're not
50%
exceeding.
rule. If you weren't exceeding the 50% rule, this existing height still wouldn't give you the 5 feet. You would need the 6 feet in order if you weren't
correct.
if you weren't modifying more than 50%. I was just trying to.
Yeah, there would have been a
Actually,
6-foot requirement. Actually, that was one of the original application requests.
Okay.
When we had the 3-story condition.
Okay.
And we said, okay, we'll eliminate.
And you weren't trying to modify more than 50%. You were trying to stay under that.
We were trying to stay at the 50%. But when we tried to eliminate another variance, we thought the variance for the height was more excessive than a setback that occurred only on the east portion of the
property.
Okay. Which is only a portion of it. We thought that was less intrusive than having a 3-story condition, which I believe the code doesn't allow a 3-story condition at the.
Correct. Okay. Is there anything else you think I should know, or?
That's all I can tell you as far as the history. I have the owners here. I think they know as much as I do. I think the neighbors are here, and they may shed some.
We'll hear from them in a minute. And you've read the conditions that are
the conditions are fine.
Staff?
We have to go to design review board, and as far as the pillars and retaining walls, I think on my plans I showed the scope of work, which says, we'll have to get a permit for, or renew all the permits that is necessary pertaining to the pillars, the walls in the front, and
So some work that pulled a permit.
There were permits
so
on
in the front of the property.
Right.
Okay.
Again, the mass and scale, the design, through staff's process, we've come as close as we can, and we'll get to design review board, and if there is any additional modification as far as aesthetic, we'll have to make it, as much as we can to code compliance. And I believe the homeowner association's concern was also, if I want to add that, they wanted something done to this home, but they wanted a design that was compatible with the neighborhood, and hopefully we achieve that.
Okay.
Thank you.
Thank you. I have only one other speaker card. Myrna Stanley? Good morning.
Good morning. Myrna Stanley, Verdugo Woodlands West Homeowners Association. Just for the record, I wanted it to reflect that our association has been involved with this address since 2004, approximately. This has been a very long road. I saw one of the neighbors the other day, and he's in his 50s, and he said he didn't think he'd live long enough to see this come to a conclusion. So hopefully he will live long enough to see that. Depends. He's still got to go to design review and then building and safety. But we understand the reason for the variances. We appreciate the reduction in number, but it's necessary. And our focus has always been, other than the mess that the prior owners have created for the neighborhood, has been the property upslope, the Castleman property. And I understand why that wall has to be there and why. In its height and the setback encroachment. We understand that. We recommend positive findings, and we look forward to design review on this project. Thank you.
Thank you. No other speakers? I know I see some other people in the audience. If the applicant has the opportunity to make any kind of rebuttal or make any other...
Thank you for giving me that opportunity, but I think I've said it all, and we hope to work with the design review board with your positive recommendation.
Okay.
Thank you.
Thank you very much. I will now close the public hearing and take this case under submission. The hearing is now officially closed. Thank you all for coming, and there are no other items on the agenda, so I will also